गुड मॉर्निंग फ्रेंड्स, आप सबों का बहुत बहुत अभिनंदन है। वीडियो में हम लोग बात करेंगे बहुत ही महत्वपूर्ण प्रश्नों की बेहतरीन श्रृंखला। तो पॉजिटिव अप्रोच के साथ बने रहिए, इस चैनल में देखते रहिए, सीखते रहिए, आगे बढ़ते रहिए, यही तमन्ना है। ऑल द बेस्ट। आपके स्क्रीन पर दिया गया सवाल पॉलिटिक्स सेक्शन से होगा। सारे प्रश्न पॉलिटिक्स से होंगे। बहुत ही बेहतरीन प्रश्नों की श्रृंखला है, आनंद लीजिए। Okay, let's start. With the reference to the Public Account Committee, consider the following statements. Public Account Committee के बारे में बताना है आपको। This committee was set up under the provisions of the Indian Council Act 1909. The members are elected by the Lok Sabha every year from among its members according to the principle of proportional representation by the means of single transfer vote. पब्लिक अकाउंट कमेटी के बारे में पूछा जा रहा है। ओके, ध्यान रहे। एवरी ईयर द फंक्शन ऑफ द कमिटी इज टू एग्जामिन द एनुअल ऑडिट रिपोर्ट ऑफ द कंप्ट्रोलर एंड ऑडिटर जनरल ऑफ इंडिया। नो अबाउट दैट। इससे पहला स्टेटमेंट ही आप छाट ही दीजिए। तीसरा स्टेटमेंट सही है। पब्लिक अकाउंट कमेटी, दिस कमिटी वाज सेट अप first in 1921 under the provisions of the Government of India Act 1919 and has since been in existence. At present, it consists of 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. The members are elected by the Parliament every year from among its members according to the principle of proportional representation by means of single transferable vote. Thus, all parties get due representation in it. The term of the members is 1 year. A minister cannot be elected as a member of committee. The chairperson of the committee is appointed from among its members by the speaker. Until 1966-67, the chairman of the committee belonged to the ruling party. However, since 1967, a convention has developed whereby the chairman of the committee is selected from opposition. The function of the committee is to examine the annual audit reports of CAG, which are laid before the Parliament by the President. The CAG submits 3 audit reports to the President, namely audit report on appropriation account, audit report on finance account, audit report on public undertaking. The committee examines public expenditure not only from the legal and formal point of view to discover the technical irregularities, but also from the point of the view of economy, prudence, wisdom, priority to bring about the cases of the waste, loss, corruption, extravagance, inefficiency, innovatory expense. Which of the following is correct about estimate committee? Lok Sabha has no representation in committee. A minister cannot be elected as a member of this committee. The chairman of the committee is invariably from the opposition. इसका पहला स्टेटमेंट गलत है बस, और केवल 2 सही है, क्योंकि ऐसा कोई जरूरी थोड़ा है। ऑपोजिशन, इसमें ऑपोजिशन की भूमिका ही नहीं है ज़्यादा। एस्टिमेट कमेटी, let's see, the origin of its committee can be traced by the Standing Financial Committee set up in 1921. The first estimate committee in the post-independence era was constituted in 1950 on the recommendation of John Mackay, then the finance minister. Originally, it has 25 members, but in 1956, its membership was raised 30. All the 30 members are from Lok Sabha only. The Rajya Sabha has no representation in the estimate committee. His members are elected by the Lok Sabha every year from among us its one member, according to the principle of the proportional representation by the means of single transferable vote. Thus, all parties get due representation in it. The term office is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed by the speaker from among its members, and he is invariably from the ruling party. With the reference to the Committee on Public Undertaking, consider the following. The committee has 15 members, consisting 10 from the Lok Sabha and 5 from the Rajya Sabha. The committee examine, public undertaking company com- committee examine the matters of the major government policy as a distinct from business or commercial function, one of the public undertakings. The chairman of the committee is appointed by the speaker from among its members who are drawn from the Lok Sabha only, not. इसका सही जवाब है केवल और केवल 3 सही. देखिए दिस कमिटी वाज क्रिएटेड इन 1964. ओके, तो पब्लिक अकाउंट कमेटी का गठन किया गया है 1964 में इन द रिकमेंडेशन ऑफ द कृष्ण मेनन कमिटी. Originally it has 15 members, from Lok Sabha 10 and 5 from Rajya Sabha. However, in 1974, its membership was raised to 22 from 15 from Lok Sabha and 7 from Rajya Sabha. The members of this committee are elected by the parliament every year from among its one members, according to the principle of proportional representation by the means of single transferable vote. Thus, all parties get due representation in it. The term of office of the members of this is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed by the speaker from among its members who are drawn from the Lok Sabha only. Thus, the members of the committee who are from Rajya Sabha cannot be appointed as a chairman. The function of the committee are to examine the reports, the accounts of the public undertakings, to examine the reports of the comptroller, the comptroller and auditor general of the public undertaking, to examine in the context of the autonomy and efficiency of the public undertaking whether the affairs of the public undertaking are being managed in accordance with the sound business principle and prudent commercial practice. To exercise such other function vested in the Public Accounts Committee, the Estimate Committee in relation to public undertaking which are allotted to it by the Speaker from time to time. The committee is not to examine and investigate any of the following: matters of major government policy as distinct from the business or the commercial function of the public undertaking, matters of day-to-day administration, matters for the consideration of which the machinery is established by any special statute under which a particular public undertaking is established. Okay. Which of the following committee is constituted by the Parliament for the purpose of scrutinizing the functioning of the government ministries and the departments in terms of expenditure and utilization of the funds? It's a public estimate committee. Estimate committee is a committee of selected members of the Parliament constituted by the Parliament for the purpose of scrutinizing the functioning of the government ministers and department in terms of expenditure and utilization of funds. The function of the committee is to examine the estimates included in budget and suggests economics in public expenditure. Hence, it has been described as a continuous economic committee. In more detail, the function of the estimate committee to report what economics improvements in organization, efficiency, the administrative reform consistent with the policy underlying the estimates can be affected to suggest the alternative policy in order to bring about efficiency and economic in administration, to examine whether the money is well laid out with the limits of the policy implied in the estimates, to suggest the form in which the estimates are to be presented to the Parliament. The committee shall not exercise its function in relation to such public undertaking as are allotted to the Committee on Public Undertaking. The committee may continue the examination of the estimates from time to time throughout the financial year and report the House as its examination proceeds. It shall not be incumbent on the committee to examine the entire estimate of the any one year. The demands for grants may be finally voted despite the fact that the committee has made no report. Consider the following statement regarding the Departmental Standing Committee. The Departmental Standing Committee, the main objective of the Departmental Standing Committee is to secure financial accountability of the Council of Ministers to the Parliament. Each standing committee consists of 22 members, 15 from Lok Sabha, 7 from Rajya Sabha. Absolutely, A is the right answer. Departmental Standing Committee. On the recommendation of the Rules Committee of Lok Sabha, 17 departmentally related standing committee were set up in the Parliament in 1993. In 2004, the 7 more such committees were set up, thus increasing their numbers from 70 to 24. The main objective of the Standing Committee is to secure more accountability of the Executive Council of Ministers to the Parliament, particularly the financial accountability. They also assist in the Parliament in debating the budget more effectively. The 24 Standing Committee cover under their jurisdiction all the ministers, departments of the central government. Each Standing Committee consisting 31 members, 21 from Lok Sabha and 10 from Rajya Sabha. The Departmental Standing Committee members of the Lok Sabha are nominated by the Speaker from among us its one members, just as a member of the Rajya Sabha are nominated by the chairman from among us its member. Minister is not eligible to be nominated as a member of any of the standing committee. In the case a member, after his nomination to any of the standing committee, is appointed a minister, he then ceases to be a member of its committee. The term of the office of each standing committee is 1 year from the date of its constitution. Out of the 24 standing committee, 8 work under the Rajya Sabha and 16 under the Lok Sabha. Which of the following departmental standing committee falls under the jurisdiction of the Rajya Sabha? Committee of Home Affairs, Committee on Science and Technology, Environment, Forest, and Committee on Agriculture. I think you know about that. One is absolutely 1 and 2. Out of the 24 departmental related committee, parliamentary standing committee of the both the houses, the following 8 committees function under the direct direction and the control of the chairman of the Rajya Sabha, that is Committee on Commerce, Committee on Home Affairs, Committee on Human Resources Development, Committee on Industry, Committee on Science and Technology, Environment, Forest, Committee on Transport, Tourism and Culture, Committee on Health, Family Welfare, Committee on Personal Public Grievances, Law and Justice. The other 16 committees function under the direction and the control of the Speaker of Lok Sabha. Which of the following committee regulates the program and timetable of the Lok Sabha and allocates time for the transaction of legislative and other businesses brought before the House of the Government? It's the Rule Committee, the Business Advisory Committee. So, Business Advisory Committee. Business Advisory Committee. This committee regulates the program, the timetable of the House. It allocates the time for the transaction of the legislative and other businesses brought before the House by the government. Lok Sabha committee consisting of 15 members, including the Speaker, its chairman. In the Rajya Sabha, it has 11 members, including the chairman as its ex officio chairman. With the reference to the parliamentary forum, consider the following statement. Parliamentary forum, respectively. The Speaker of the Lok Sabha is the ex officio president of all the parliamentary forums. The objective behind the constitution of the parliamentary forum is to provide a platform to the members to have interaction with the minister concerned with a view to have a focused and meaningful discussion on a critical issue. I think B is the right answer. The objective behind the constitution of parliamentary forum are to provide a platform to the members to have an interaction with the minister concerned, expert and key official from nodal ministries with a view to have a focused and meaningful discussion on a critical issue with a result-oriented approach for speeding up the implementation process to sensitize the members about the key areas of concern and also about the ground level situation and equip them with the latest information, knowledge, technical know-how, and the valuable inputs from experts both from the country and abroad for enabling them to raise these issues effectively on the floor of the House and in the meetings of the departmental related standing committees to prepare a database thorough collection of data on a critical issue from ministries concerned, reliable NGO, newspaper, United Nations, Internet, etc., and the circulation of thereof to the members so that they can meaningfully participate in the discussion of the forums and seek clarification from expert or official from the ministry present in this meeting. The Speaker of the Lok Sabha is the ex officio president of all the forums except the parliamentary forum on population and public health, where in the chairman of Rajya Sabha is ex officio. You remember about that? Parliamentary forum of population and public health, where in the chairman of the Rajya Sabha is ex officio. President of this and the speaker is the ex officio president. Co-president. The deputy chairman of the Rajya Sabha is the deputy speaker of Lok Sabha. The concerned minister and the chairman of departmentally related standing committees are the ex officio vice president of the respective forum. Each forum consists not more than 31 members, excluding president, co-president, and vice president, out of whom not more than 21 from Lok Sabha and not more than 10 from Rajya Sabha. Consider the following statement. The Committee on Subordinate Legislation examine all papers laid on the table of the House by ministers to see whether they comply with provisions of the Constitution or related act or rule. The Committee of Privilege enforce the code of conduct of the members of the Parliament by examining the case of misconduct and the recommending appropriate action. Which of the above is correct? So D. Committee on Subordinate Legislation. This committee examines and reports to the House whether the powers to make regulation, rules, sub-rules, bylaws delegated by the Parliament or conferred by the Constitution to the Executive are being properly exercised by it. In both the Houses, the committee consists of 15 members. It was constituted in 1953. Committee on Papers laid on the table. This committee was constituted in 1975. The Lok Sabha committee has 15 members, while the Rajya Sabha committee has 10 members. It examines all papers laid on the table of the House by minister to see whether the, they comply with provisions of the Constitution or related act or rule. It does not examine statutory notification and orders that fall under the jurisdiction of the Committee on Subordinate Legislation. Committee of Privilege. The functions of the committee are semi-judicial in nature. It examines the cases of the breach of the privilege of the House and its members and recommendation appropriate action. The Lok Sabha committee has 15 members, while the Rajya Sabha committee has 10 members. Ethics Committee. This committee was constituted in Rajya Sabha in 1997 and in Lok Sabha it is in 2000. It's very important. The committee was constituted in Rajya Sabha in 1997 and in Lok Sabha in 2000. It enforces the code of conduct of members of the parliament. It examines the cases of misconduct and recommends appropriate action. Thus, it is engaged in maintaining the discipline and decorum in the parliament. Consider the following statement. The single system of courts to both the central laws as well as the state laws was adopted from the Government of India Act 1990. Part 6 of the Indian Constitution deals the organization, independence, jurisdiction and the powers of the Supreme Court. Okay, which are the correct? I think D is the right answer. Indian Constitution has established an integrated judicial system with the Supreme Court at the top level and the High Courts at the middle level. Under a High Court, below the state level, there is a hierarchy of the subordinate courts, that is district courts and other lower courts. The single system of courts adopted from the Government of India Act 1935 enforces both the central level as well as the state level. The Supreme Court of India was inaugurated on January 28, 1950, which succeeded the Federal Court of India that was established under the Government of India Act 1935. However, the jurisdiction of the Supreme Court was greater than that of its predecessors. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. In Article 124 to 147 in Part 5 of the Constitution deal with the organization, independence, jurisdiction, powers, procedure, and so on of the Supreme Court. The Parliament is also authorized to regulate them. A person to be appointed as a judge of the Supreme Court should have been a judge of a High Court for 10 years. The salaries, allowances, pension of the Supreme Court judges are just charged upon the Consulate Fund of India. Yes, B is the right. You know about that, the qualification of the Supreme Court. A person to be appointed as a judge of the Supreme Court should have the following qualifications. Should have be a citizen of India. He should have been a judge of the High Court or High Court in succession for 5 years. So 5 years. He should have been an advocate of a High Court or High Courts in succession for 10 years. He should be a distinguished jurist in the opinion of this President. From the above, it's clear that the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Their salary, allowances, the pension of the judges of the Supreme Court are charged upon the Consulate Fund of India. They cannot be varied to their disadvantage after their appointments except during the financial emergency. Consider the following statement. A judge of the Supreme Court holds office for 5 years until the age of 65 years, whichever is earlier. A judge of the Supreme Court can resign his office by writing to a Chief Justice of India. ओके, पहला स्टेटमेंट गलत है, दूसरा स्टेटमेंट गलत है। ठीक है, टेन्योर ऑफ जजेस, द कॉन्स्टिट्यूशन हैज नॉट फिक्स the tenure of a judges of the Supreme Court. However, it makes the following three provisions in this regard. He holds office until he attains the age of 65 years. Any question regarding his age to be determined by such authority or in such a manner as provided by the Parliament. He can resign his office by writing to the President. He can be removed from his office by the President on the recommendation of the Parliament. With reference to the removal of the judges of the Supreme Court, consider the following. Judges Inquiry Act 1968 determines the procedure of removal of the judges of the Supreme Court. A motion of impeachment a judge addressed to the President is to be decided by at least 50 members of the Lok Sabha or Rajya Sabha. It's a 50-member. Motion for removal of the judges should be passed by each house by the Parliament by special majority. Just only a special majority? Not at all. You know about that? 1 and 2, 2 and 3. So 2 and 3 is right answer. Judges of the Supreme Court can be removed from his office by an order of the President. The President can issue the removal order only after the address by the Parliament has been presented to him in the same session for the such removal. The address must be supported by the special majority of each house of the Parliament. Special majority of each house of the Parliament. A majority of the total membership of the House and majority of not less than the two-thirds of the members of that House present and voting. The grounds of the removal are the two proved misbehavior or incapacity. The Judges Inquiry Act 1968. Judges Inquiry Act 1968 regulates the procedure relating to the removal of the judges of the Supreme Court by the process of impeachment. A removal motion signed by 100 members in the case of Lok Sabha or 15 members in the case of Rajya Sabha is to be given to the Speaker or the Chairman. The Speaker, the Chairman may admit the motion or refuse to admit it. If it is admitted, then the Speaker, the Chairman, is to constitute a three-member panel to investigate the, the charges. The committee should consist of the Chief Justice or the judges of the Supreme Court, a Chief Justice of a High Court, and a district jurist. If the committee finds the judge to be guilty of misbehavior or suffering from incapacity, the House can take up the consideration of the motion. After the motion is passed each House by the Parliament with a special majority, an address is presented to the President for the removal of judges. Finally, the President passes an order removing the judge. No judge of the Supreme Court has been impeached so far. The first case of impeachment is the Justice V. Ramaswamy of the Supreme Court in 1991 to 1993. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in Lok Sabha. The Congress party abstained from voting. Consider the following. The President appoints a judge of High Court as an ad hoc judge of the Supreme Court for a temporary period when there is a lack of quorum of the permanent judges. Consent of the President is required by the Chief Justice of India to appoint a retired judge of the High Court to act as a judge of the Supreme Court for a temporary period. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India when the office of the Chief Justice of India is vacant. इसका सही जवाब केवल और केवल 2 और 3 है। देखिए एडहॉक जजेस क्या होता है। When there is a lack of quorum of the permanent judges of the to hold or to continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a temporary period. He cannot do so only after consultation with the Chief Justice of the High Court, concerned with the previous consent of the President. The judge so appointed should be qualified for the appointment of a judge of the Supreme Court. It is the duty of the judge so appointed to attend the sitting of the Supreme Court in priority to the other duties of his office. While attending the sitting of the Supreme Court, he enjoys all the jurisdiction, powers, privileges of the judges of the Supreme Court, retired judge. At any time, the Chief Justice of India can request a retired judge of a Supreme Court or a retired judge of a High Court who is duly qualified for the appointment of the judges of the Supreme Court to act as a judge of the Supreme Court for a temporary period. He can do so only with the prior consent of the President and also for the person to be appointed. Such a judge is entitled to serve allowances as the President and may determine he also enjoy all the jurisdiction powers and the privilege of the judges of the Supreme Court, but he will not otherwise be deemed to be a judge of the Supreme Court. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India when the office of the Chief Justice of India is vacant, the Chief Justice of India is temporarily absent, the Chief Justice of India is unable to perform the duties of his office. Consider the following statement. The references made by the President of India to the Supreme Court under Article 143 are decided by the bench consisting of at least 5 judges. The Constitution authorizes the Parliament of India to appoint the place or the places other than Delhi as a seat of the Supreme Court. It's not a Parliament, it's a President. The references made by the President of India to the Supreme Court under Article 143 are decided by the bench consisting at least 5 judges. Not at all, not at all. So one is right. Procedure of the Supreme Court of India. Supreme Court can, with the approval of the President, make rule for regulating generally the practice and the procedure of the court. Constitutional cases or references made by the President under Article 143 are decided by the bench consisting at least 5 judges. All other cases are decided by the single judges and division benches. The judgments are delivered by an open court. All judgments are by majority vote, but if differing, then judges can be dissenting the judgment or opinion. Seat of the Supreme Court. Constitution declares Delhi is the seat of the Supreme Court, but it also authorizes the Chief Justice of India to appoint other places as a seat of the Supreme Court. He can take decision in this regard only with the approval of the President. This provision is the only optional, not compulsory. This means that no court can give any direction either to the President or to the Council or to the Chief Justice to appoint any other places as a seat of the Supreme Court. Constitution provides which of the following provisions to safeguard and ensure the independent and the impartial functioning of the Supreme Court. Constitution. The Constitution prohibits any discussion in Parliament or in any state legislature with respect to the conduct of the judges of the Supreme Court in the discharge of their duties. Chief Justice of India can appoint officers and servants of the Supreme Court without any interferences from the executive. The Parliament is not authorized to curtail the jurisdiction and the power of the Supreme Court. 1 and 3. 1, 2, 3, all are correct. Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. Let's see. Mode of appointment. The judges of the Supreme Court are appointed by the President, which means the Cabinet, in consultation with the members of the judiciary itself. Judges of the Supreme Court and the High Courts. These provisions curtail the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical consideration. Security of tenure. The judges of the Supreme Court are provided the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of the Supreme Court has been removed so far, impeached so far. Fixed service condition. The salaries, the allowances, the privilege, the leave, the pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be changed to their disadvantage after their appointment except during the financial emergency. Thus, the condition of the services of the judges of the Supreme Court remains same during their term of office. Expenses charged on consolidated fund. The salaries, allowances, the pension of the judges and the staff, as well as the all administrative expenses of the Supreme Court are charged on consolidated fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. Conduct of judges cannot be discussed. The Constitution prohibits discussion in the Parliament or in the state legislature with respect to the conduct of the judges of the Supreme Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. Ban on practice of retirement. The retired judge of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of the future favor. Power to punish for its contempt. The Supreme Court can punish any person for its contempt. Thus, its action and decision cannot be criticized and opposed by anybody. This power is vested in the Supreme Court to maintain its authority, dignity, and honor. Freedom to appoint its staff. The Chief Justice of India can appoint officers and servants of the Supreme Court without any interference from the executive. He can also prescribe the conditional of service. Its jurisdiction cannot be curtailed. Parliament is not authorized to curtail the jurisdiction and the powers of the Supreme Court. The Constitution has guaranteed to the Supreme Court jurisdiction of various kinds. However, the Parliament can extend separation from executive. Constitution directs the state to take steps to separate the judiciary from executive in the public services. This means that the executive authorities should not possess the judicial powers. Consequently, upon its implementation, the role of the executive authorities in judicial administration came to an end. For which of the following cases of the Supreme Court has exclusive jurisdiction? Dispute between the center and one or more states, dispute between two or more states, interstate water dispute, only one and two. A federal court, the Supreme Court decide the disputes between different units of Indian Federation. More elaborately, any dispute. Any dispute between the center and one or more states, between the center and any state, or states on one side and one or more other states on the other side, between two or more states. In the above federal dispute, the Supreme Court has exclusive jurisdiction. Exclusively means no other court can decide such disputes, and original means the power to hear such disputes in the first instances, not way appeal. With regard to the exclusive jurisdiction of the Supreme Court, two points should be noted here that the dispute must involve a question whether a law or fact on which the existence or the extent of a legal rights depends. Thus, the question of a political nature are excluded from it. Any suit brought before the Supreme Court by a private citizen against the center or the state cannot be entertained under this. Further, this jurisdiction of the Supreme Court does not extend to the following: a dispute arising out of any pre-constitutional treaty, agreement, convent, engagement, sansad or sanad or other similar instrument pre-constitution, a dispute arising out of any treaty, agreement, etc., which specifically provides that this jurisdiction does not extend to such a dispute. Inter interstate water dispute, matters referred to the Finance Commission, adjustment of a certain expenses and pension between the center and the states, ordinary dispute of a commercial nature between the center and the states, recovery of damage by a state against the center. In 1961, the first suit under the original jurisdiction of the Supreme Court was brought by the West Bengal against the center. The state government challenged the constitutional validity of the Coal Bearing Areas Acquisition and Development Act 1957, passed by the Parliament. However, the Supreme Court dismissed the suit by upholding the validity of the Act. Consider the following statements. The read jurisdiction of the Supreme Court is original and exclusive. The Supreme Court can issue reads only for the enforcement of the fundamental right, which are correct. Only two. Read jurisdiction of Supreme Court. The Constitution has constituted the Supreme Court as the guarantor and defender of the fundamental rights of the citizen. The Supreme Court is empowered to issue writs including habeas corpus, mandamus, prohibition, quo warranto, certiorari for the enforcement of the fundamental rights of an aggregate citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggregate citizen can directly go to the Supreme Court, not necessarily by the way of appeal. However, the read jurisdiction of the Supreme Court is not exclusive. The High Court are also empowered to issue writs for the enforcement of the fundamental rights. It means when the fundamental rights of the citizen are violated, the aggregate party has the option of moving either High Court or the Supreme Court directly. Therefore, the original jurisdiction of the Supreme Court with regard to federal dispute is different from its original jurisdiction with regard to the dispute relating to the fundamental rights. In the first case, it is exclusive, and in the second case, it is a concurrent to the High Court jurisdiction. Moreover, the parties involved in the first case are the units of the federation, center and states, while the dispute in the second case is between the citizen and the government, center or state. There is also differences between the rate jurisdiction of the Supreme Court and the other high courts. The Supreme Court can issue writs only for the enforcement of the fundamental rights, not for the other purposes. The High Court, on the other hand, can issue writs not only for the enforcement of the fundamental rights, but also for the other purposes. It means that writ jurisdiction of the High Court is wider than of the Supreme Court, but the Parliament can confer on the Supreme Court the power to issue writs for the other purpose also. Consider the following statements. Supreme Court of India of may refuse to tender its opinion to the President on any question of law or fact of a public importance which has arisen or which is likely to rise. क्या सुप्रीम कोर्ट रिफ्यूज कर सकता है प्रेसिडेंट के ओपिनियन को? The opinion expressed by the Supreme Court of India to the President is only advisory and not a judicial pronouncement. Yes, दोनों स्टेटमेंट भैया करेक्ट हैं. देखिए, एडवाइजरी जुडिक्शन ऑफ सुप्रीम कोर्ट. एडवाइजरी जुडिक्शन ऑफ सुप्रीम कोर्ट क्या है? कॉन्स्टिट्यूशन आर्टिकल 143 authorizes the President to seek the opinion of the Supreme Court in the two categories of matters on any question of law or fact of public importance which has arisen or which is likely to arise, or any dispute arising out of any pre-constitutional treaty, agreement, convent, engagement, salary, or similar institution. In the first case, Supreme Court may tender or may refuse to tender its opinion to the President. But in the second case, the Supreme Court must tender its opinion to the President. In both the cases, the opinion expressed by the Supreme Court is only advisory, not a judicial pronouncement. Hence, it is not binding on the President. He may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. Which of the following statements are correct regarding the High Court in India? The judges of the High Courts are appointed by the governor of the concerned state. The Chief Justice of High Court is appointed by the President after the consultation with the Chief Justice of India and the governor of the state concerned. Only B is the right. You know about that institution of High Court originated in India in 1862 when the High Court were set up at Calcutta, Mumbai, Madras. The Constitution of India provides for a High Court for each state, but the Seventh Amendment Act 1956 authorizes the Parliament to establish a common High Court for two or more states and a union territory. Appointment of judges. The judges of the High Courts are appointed by the President. The Chief Justice is appointed by the President after the consultation with the Chief Justice of India and the Governor of the concerned state concerned. For the appointment of other judges, the Chief Justice of the concerned High Court is also consulted. In the case of a common High Court for the two or more states, the Governor of the all states concerned are consulted by the President. Consider the following statements. A judge of a high court can be removed in the same manner and on the same grounds as a judge of the Supreme Court. A judge of a high court holds office until he attains the age of 65. The President can transfer a judge from one high court to another high court after consulting the Chief Justice of India. दूसरा स्टेटमेंट तो गलत है भाई, चलिए एक और तीन सही है. Tenure of judges of high court. The Constitution has not fixed the tenure of the judges of the high court. However, it makes the following four provisions in this regard. He hold office until he attains the age of 62 years. Any question regarding his age to be decided by the President after consultation with the Chief Justice of India, and the decision of the President is final. He can resign his office by writing to the President. He can remove from his office by the President on the recommendation of the Parliament. He vacate his office when he is appointed as a judge of the Supreme Court, when he is transferred to the another high court. Removal of judges of high courts. A judge of a high court can be removed from his office by an order of the President. The President can issue the removal order only after an address by the Parliament has been presented to him in the same session for such removal. The address must be supported by the special majority of each house of the Parliament, the majority of the total membership of the House, the majority of the not less than two-thirds of the members of the House present and voting. The grounds of the removal are the true proved misbehavior or incapacity. The judge of a high court can be removed in the same manner or in the same grounds as the judge of the Supreme Court. Transfer of judges of high courts. The President can transfer a judge from one high court to the another high court, consulting the Chief Justice of India. On transfer, he is entitled to receive in addition to his salary such compensatory allowances as may be determined by the Parliament. Consider the following statements. The condition of the service of the judges of the High Court are determined by the concerned state legislature. Condition of service of judges of the High Court are determined by the concerned state legislature. The salary, the allowances, the pension of the judges of the High Court are charged on the consolidated fund of the state. Absolutely incorrect. केवल और केवल दोनों सही नहीं है. Salary, allowances, privilege, leave, pension of the judges of the High Court are determined from time to time by the Parliament. Salary, allowances, privilege, leave, pension of the judges of the High Court are determined from time to time by the Parliament. But they cannot be changed to their disadvantage after their appointment, except during a financial emergency. Thus, the condition of the service of the judges of the high courts remains same during their term of office. The salary, the allowances of the judges, the salary and allowances and pension of the staff, as well as the administrative expenses of the high court, are charged on the consolidated fund of the state. ध्यान रहे, salary and allowances of the judges, the salary, allowances, and the pension of the staff as the administrative expenses of a high court are charged on consolidated fund of the state. Thus, they are non-votable by the state legislature. But याद रखिएगा आप, it should be noted here that the pension of the high court judges is charged on consolidated fund of India, not the state. High Court has original jurisdiction regarding dispute relating to the election of the members of the Parliament and the state legislature. High Court has original and exclusive jurisdiction regarding the enforcement of the fundamental rights of the citizen. The lead jurisdiction of the High Court is concurrent with the jurisdiction of the Supreme Court. Yes, of course. केवल और केवल 3 सही है कि 1 और 3 सही है, 1 और 3 सही, दोनों सही है. यस, 1-3, क्योंकि इंदिरा गांधी का याद होगा आपको, राजनारायण केस. ओरिजिनल जुडिक्शन ऑफ हाई कोर्ट, ओरिजिनल, not exclusive, original. It means that the power of the high court to hear dispute in the first instances, not by the way of appeal. It extends to the following: matters of admiralty and the contempt of the court. Matters of admiralty and the contempt of court. Dispute relating to the election of the members of the parliament and the state legislature. Regarding revenue matters or an order or done in the revenue collection. Enforcement of the fundamental rights of citizens. Cesses order to be transferred from a subordinate court involving the interpretation of the Constitution to its one file. The 4 high courts, Calcutta, Mumbai, Madras, and Delhi, have an original civil jurisdiction in the cases of higher value. Before 1973, Calcutta, Mumbai, Madras high courts also had an original criminal jurisdiction. This was fully abolished by the Criminal Procedure Code 1973. Read jurisdiction of Supreme Court. Article 226 of the Constitution empowers a high court to issue writs including habeas corpus, mandamus, sorcery, prohibition, quo warranto for the enforcement of the fundamental rights of the citizen and for any other purpose. यहाँ जो purpose, any phrases the for any other purpose refers to the enforcement of any ordinary legal right. High Court can issue writs to any person, authority in the government not only within its territorial jurisdiction but also the outside of its territorial jurisdiction if the case of action arises within its territorial jurisdiction. The writ jurisdiction of the High Court under Article 226 is not exclusive but concurrent with writ jurisdiction of the Supreme Court, Article 32. It means that when the fundamental rights of a citizen are violated, the aggrieved party has the option to for moving either the High Court or the Supreme Court directly. However, the writ jurisdiction of the High Court is wider than that of the Supreme Court. This is because the Supreme Court can issue writs only for the enforcement of the fundamental rights and not for any other purpose. That is, it does not extend to a case where the breach of the ordinary legal right is alleged. तो इसी पॉजिटिव नोट्स के साथ पॉजिटिव अप्रोच बनाए रखिए, लगातार सीखते रहिए, सॉल्व करते रहिए, सुनते रहिए वीडियोस को 2-3 बार, then you will feel yourself, yes, I am in good position to solve the problems of the qualities. Such type of question is very good concept, requirement to read 2 or 3 times. But if you have a general understanding about your concept from your books, then you can solve such type of problems easily in your examination hall. So watch the videos 2 or 3 times, you will be in good position in polity. Thank you.